AI has gotten more legal friendly, lawyer friendly, I'm finding that we're engaging with more educated consumers. What I mean by that is, in the past, in the personal injury world, oftentimes somebody was coming to us with zero experience. And one of the nice things now, it's both nice and a problem, is that they're much more educated. They've done some digging on AI and have some sense. They may have even drafted a demand package that they've sent off to the insurance company themselves before they've come to us. The downside is the education that they've gotten is from AI. It's not always perfect, and sometimes it's given them some unrealistic expectations that need to be toned down. Howdy, and welcome to Cooper's Code. We're here with our occasional AI episode with Marshall Cole and Shahrad Milanfar. Thanks for joining, and Marshall, nice to have you back from your trials. We're just going to dive right into stuff. We've got a lot of interesting things to cover today. Everything from social media trials to prompting to pro-pers using hallucinations to AI products and the potential in MedMal cases there. So without further ado, I think, Marshall, we'll kick it to you. It sounds like you were giving a talk at the Santa Barbara Aboda recently and talking a bit about how AI is showing up as a potential maybe defendant in a case. Maybe you can unpack that a little bit.
Yeah, sure. I mean, on this podcast, we've talked a lot about lawyers and how we're using AI and how we're getting it wrong and people are making mistakes and all the things related to that. And I sort of shifted the focus on, we as lawyers now, on behalf of your clients, need to be looking for cases that are arising out of AI and its misuse in other industries. And obviously, every other industry is using it, probably using it, or should be using it. And just like in the legal community, they're getting it wrong and messing things up as well. And so I was looking at a particular article regarding this nasal surgical device that was being used, and they had implemented artificial intelligence several years ago. And prior to implementing it, they had only had 7 malfunctions or sort of botched cases, which would cause, significant damage to the person. But then since implementing AI, the malfunctions rose to being in excess of 100. And, the injuries are skull punctures, cerebral spinal fluid leaks, carotid artery damage. And so when you look at that type of a case, then you sort of unpack that and looked at, who do you pursue, right? You've got the physician who may or may not have used it appropriately. You've got the AI manufacturer. You've got the hospital and the systems in place there. And so, prior to the advent of AI, you would have arguably looked at that as a traditional medical malpractice case. A lawyer botched a surgery, caused injuries, and, is damaged and damaged the patient. Now, with AI involved, if that's a third-party manufacturer, you've got a potential product liability claim. And as we were discussing offline, with microcaps in relation to that apply to MedMal cases, if you add a product liability component to it, you move it outside of that realm, and can recover a lot more money for your client, depending on what the circumstances are. And this was just a pretty, basic example of a case study where this was going on. And I'm sure if you are in this field, you don't have to scratch very deep into the surface to find other areas of medicine where AI is being used. I know it's definitely being used for radiologists looking at scans. And, I'm sure it's only a matter of time before people are starting to get it wrong by over-relying upon AI and getting misdiagnoses or misdiagnosed or however it might be. So it was a really engaging discussion and just kind of a refreshing way to look at and think about, as lawyers, AI, not just how we're using it and should and shouldn't be using it, but how all the consumers out there are using it and potential cases that exist. And then even on the defense side, you need to be looking out for your clients and advising them, just like, we've been doing in the past episodes for lawyers, for appropriate usage or responsible and ethical usage of artificial intelligence.
Shahrad, have you come across this and I know you do a wide variety. I always think of you as the elder abuse guy giving your verdicts, but I know you do a wide variety of things. Have you started coming across this in ways where, like, you're questioning, say, a PMK and finding that, oh wait, there's actually a potential other defendant behind these defendants with an AI tool or anything along those lines?
I haven't had anything specific come up in that context, but just kind of putting my defense lawyer hat on from prior experience. I mean, especially if you're a defense lawyer defending a doctor who has what's known as a hammer clause and says, I don't want to settle this case, it wasn't my fault. A great way to kind of get your client out of hot water is to find out if there was something else that caused the injury. And if that something else is AI, which doesn't have a med mal cap attached to it, that would be a significant piece of information that could help not only your client, but could also help the person who was injured. And these are things that Marshall is talking about, in my opinion, is that you have to look outside the box and kind of take the blinders off and always look for new things that can help our clients achieve their goals in litigation.
It certainly feels like in taking depositions, MedMal, any other area, some good open-ended questions about whether was there any sort of AI assist, any tools, anything built into Epic. That's the majority of hospitals and doctors use an Epic system where there are some tools that reside within there in terms of their medical charts.
I think depo questions are a definite addition to the tool belt of a MedMal lawyer or anyone, or really anything. I mean, if you're deposing a PMK of a finance company, I mean, if they've implemented it, how the algorithms are working, what are they doing, what are their recommendations based upon, what's the human component and where does that intersect with AI? And inevitably right now at that cross point, something's potentially going wrong.
Well, and I think we all have had experiences if you've handled any kind of trucking cases. I used to do tons and tons of trucking cases and downloading the electronic control module on those trucks. Now they have cameras that are facing the driver where they may have AI monitoring to see if this driver is getting drowsy. And all of those things are things that we have to ask about and see, what's the worst that can happen? They didn't use it. But if they did use it, that could be significant information that could be useful in prosecuting your case in a trucking case or even any kind of a ride share type case that might come up.
Anything further on this topic before I feel, Marshall, with you being in Los Angeles, I'm anxious to get to social media trials and Mark Lanier and Mark Zuckerberg and things along those lines.
No, it was something that came up and I thought it was just an interesting thing for lawyers to start focusing on. And I'm sure many have, but in handling your cases, you need to start adding questions in discovery, regarding AI, depots, cross-examining witnesses, expert witnesses, the standard of care, right? Does it or does it not require the use of AI? I think it's very field dependent, but if you're not asking about it, I think there's a big gap of information you're leaving behind. You don't know, you're not benefiting your client. So that was all I thought would be beneficial to kind of bring that up and just another way for us to think about using it.
So the takeaway is on the deposition checklist, make sure that there's a slot for AI now to see if there's any potential big, broad, open-ended questions to see if there's something there.
Yeah. And then I think you need to, in the particular field, as you narrow down those questions, you're going to need to become more educated to know the appropriate questions, right? I mean, asking, do you use AI? I mean, the person you're deposing may not even know.
Right.
You got to define it. They've got to know what it is. That general term, artificial intelligence, is so broad that I don't think you'll get very effective and useful answers without knowing exactly what specific AI tools are being used, how they're being used. And I think the only way you learn about that is by learning more and more about the different artificial intelligence tools that exist in those various fields.
Not to go too far off field, but that goes into how you take depositions and the funnel technique that's taught in the National Institute for Trial Advocacy programs, right? Is if you ask what types of systems or what are the names of the systems that you use, you can almost get real-time information on them because of the AI systems that are out there available to allow you to do research as you're asking the questions. So it's kind of a two-way street in the sense that we want to know what they're doing, but also what tools are we using to get educated on those topics.
And to your point, I think both your points, that the physician or healthcare provider may not even be aware that there is some back-end tool. It's, when the radiologist says, well, the computer told me it was likely non-cancerous, it's listening, oh, what do you mean the computer told you? That's where the dig is.
Right.
Yeah. Or if they even take that answer, if they just say, I didn't see it, right? Is it really them who didn't see it? And you have to ask that follow-up question. I think most lawyers, rightfully so, would accept that answer, right? I didn't see it. I missed it, whatever it might be. But the I is a big difference now. There's a lot more there that you need to ask other than, okay, accept that answer, move on, doctor messed up, whatever.
As we transition into the social media trial, I have to ask, Shahrad, are those glasses that you're wearing Meta glasses?
Not a chance.
I bring that up only because from media management side, I have no idea how the trial is going to turn out. I will say Zuckerberg showing up being phalanxed by Meta glass wearing security seemed like a bad look going into this thing. That's just my kind of catty comment there. I don't know if either of you have strong feelings about that.
I saw something that's indicated that the judge noticed people in the audience wearing Meta glasses and basically gave a very stern warning that any recording that was done in the courtroom must be deleted because they don't want the face of the jurors out there. And then one of the lead attorneys in the case also gave an interview in the first floor of the courthouse on Zoom. And that apparently violated the court's orders on no photography inside the courthouse. So there's, and that kind of goes to what we all talk about in terms of social media as well. But this trial has a number of different layers that from just a human interest standpoint, I think we should all be watching.
Definitely. And I tell people I don't follow sports, I follow lawyers. And so when you look at somebody like Mark Lanier, who did the first Vioxx trial and just kind of has a record of being one of the go-to guys for the bellwether cases, I have to imagine that it's quite an experience to watch him take a witness like Mark Zuckerberg or the head of Instagram. It did not sound like, at least from the digest version that we're getting from outside the courthouse, that those went particularly well for the defense.
Yeah, I mean, I think the press was that Zuckerberg was very combative and indicating that he was being, taken out of context and it's not what people think it is. But when your own internal documents, you have your staff saying, Instagram is a drug, and then the response is, yeah, and we're the pushers. That's a hard thing to defend, regardless of who you are and how smart you are. And I don't know how well Mark Zuckerberg did. He seems like he's worked on his personality over the years, but having seen him testify before Congress, I would love to see the video of how that exchange goes with Mark Lanier, who is a very polished and incredibly prepared lawyer.
One other piece that I thought was interesting in terms of the examination and kind of a wise move, to the extent that Zuckerberg was more polished and more capable than he has been in the past, using the hundreds of hours of media training that he has been subjected to as part of the cross. I thought that was an interesting approach.
I thought so too. And I think he acknowledged, this isn't my strong suit, right? I'm not that good at this. So, take what I say with a grain of salt in some ways. And I think, I understand why he said it. And I think that was good prep for him to say something like that. But like you said, Shahrad, I think it's a tough position to defend. He's on the one hand trying to do a good thing, offer service to millions and millions of people. And on the other hand, bad things are happening because of it. And he's at an intersection of profits versus sort of ethical issues.
Well, I think that intersection is way in the rear mirror. I mean, going back to Marshall's point in terms of looking at different ways to bring cases, this is an excellent example, right? Because the Section 230 typically would bar any kind of liability for these companies, but yet because it's couched as a product liability case, that's been a very effective way of getting around that particular statute. So again, it's Mark Lanier and I believe Rahul Ravapudi is involved in that case as well, are being very creative in how they're doing their job and able to get it to trial, which is not an easy task.
As a parent who is, I've got a 12 and 13-year-old, and who is seeing how addictive these tools are, I am cautiously optimistic that this kind of approach, if we can't rein it in through Congress, perhaps we can rein it in through dollars, is part of my sentiment.
I think it's the most effective way. I mean, I think the most enjoyable videos I saw were of Zuckerberg getting served with various other lawsuits as he was walking in and out of the courthouse. I mean, these people aren't very accessible, except in moments like this where they are rarely, in a public place exposed. Who knows what they're being served with? But I thought that was just a little bit of a funny anecdote to take away from the whole thing that's going on.
Either of you have any predictions just based on what you've read in terms of the case?
I think the cases like this are tough. I get it. I see the avenue to prevailing. I think it is addictive. I think, the age verification process, on the other hand, is hard for them to get right. But I just think when you look at the particular elements of what the plaintiffs needed to prove, I think it's still tough, But so I see both sides of it, from the moral side, the moral victory, why the plaintiffs should prevail here for all the right reasons. But then I think there's just the legal hurdles that they have to overcome to actually meet the burden of proof.
Yeah, but that's why we have good lawyers on both sides, and that's why these things are tried. I mean, if it was a slam dunk for one side or the other, you never go to trial.
Yeah. I always say the juries get it right, whatever, that they get it right. So they'll get it right. That'll be the right decision, whatever it is.
I'm excited to see what the outcome is. It has been interesting to follow this case. Along the lines of cases, flipping it back to you, Marshall, a couple months ago, I think November at this point, you had a pro per who had done some motion practice with hallucinated cases. And I know that was pending back then. And one of the things we said is we're going to return to it. And so I had a little footnote to make sure that we came back to that to see how that got handled by the judge and use that kind of as a launching pad in terms of AI experiences with people who are going the path without lawyers. So
most of my practice is defending lawyers. And so for whatever reason, oftentimes I deal with pro pers as plaintiffs who sue their former counsel. And, at any given time, I probably, in the office, we probably have, 5 to 7 pro pers we're doing. And in this one particular instance, this pro per, the case has been pending for a very long time. And, obviously started using AI to write briefs, and it was pretty obvious that was happening. And it was only a matter of time before hallucinated cases that didn't exist were going to pop into those motions, which happened in one such instance. Motion denied, court very stern ruling, but no real repercussions other than that. If it was a lawyer, it certainly would have been a lot worse. Or for myself, if I had done it, it would have been a lot worse, right? It would have been another headline that we've seen dozens and dozens of at this point in time. But separate from that, in another case that I've got with a pro per who started using it all across the board and in my email communications, you could see overnight he figured out how to start using whatever it is, probably ChatGPT, and his emails sound very lawyerly. And I presume he's writing a couple sentences and says, make this sound like a lawyer. And sure enough, it does a pretty darn good job. And I've outlined in my response emails, you don't need to use AI to draft your emails. It's perfectly fine. Just we can communicate. We were doing it before. There's no difference here. And it's so obvious. Just stop. But he won't listen. That particular individual hasn't submitted anything with hallucinated cases or, fabricated legal positions. It's all been accurate. And he's done a much better job than he was previously doing. And he's still going to run into a wall at some point. But I think, for pro per litigants, they're going to have a major leg up if they figure out and know how to just check to make sure that the things they submit to the court aren't fake. They'll certainly take better depositions, which I know this gentleman will when the time comes. He's going to have an outline. He's going to ask questions that are going to be well-formed. That'll probably get around a lot of objections that otherwise would have been asserted in the past. And so, I fully expect to see the pro per world by and large improve with, 2 steps forward, 1 step backward kind of thing. But they're going to be using it and are using it. And I see it on a regular basis now. And it's mostly entertaining for me at this point, but it's definitely interesting to see. There's the ones who file motions with accurate case law are far more convincing and compelling than they otherwise would have been. And you have to deal with them like they really are a lawyer, as opposed to kind of slapping them around a little more when they didn't have any ability to put forth a good argument. So it's an interesting thing that's really just taken off.
As AI has gotten more legal friendly, lawyer friendly, I'm finding that we're engaging with more educated consumers. What I mean by that is, in the past, in the personal injury world, oftentimes somebody was coming to us with zero experience. And one of the nice things now, it's both nice and a problem, is that they're much more educated. They've done some digging on AI and have some sense. They may have even drafted a demand package that they've sent off to the insurance company themselves before they've come to us. The downside is the education that they've gotten is from AI. It's not always perfect, and sometimes it's given them some unrealistic expectations that need to be toned down. That's a launchpad for a question for both of you. Perhaps Shahrad to start. Are you finding that you're getting more educated people, or people who you can tell just in the conversation with them that they've done some digging before they're talking with you?
Yeah, I think there's definitely an element of that that's appearing. It's just part of what AI is doing, just from a social fabric perspective, is becoming almost a confidant to people, right? Which is what led to the suicide cases that we're reading about. And the toy case that I told you about, there's now AI toys for children where the kid can talk to the AI and literally have interactions as if this is their best friend. So I don't think that it's unusual for people who are in horrible situations, they've been in a horrific crash, to think, all right, where do I start? Maybe AI can guide me in the right direction. So I don't blame them. It's just that there are potential pitfalls, especially if you're a criminal defendant, as in the case that we're going to talk about, and you decide to go to ChatGPT and put in a bunch of information that then the FBI gets through a search warrant that they execute on your house.
Yeah, I've had clients of mine who are lawyers take work product of mine, and I know they've put it through AI to edit it and revise it and send it back to me. And I've asked that because it comes out, and when you see it enough and you use it enough, you still can really tell the difference. Also, the speed at which they've revised something and sent it back. And I asked them, is that what you did? And they all say yes. And I'm like, well, let me tell you why, we don't want to use that version completely. Now, certainly some suggestions come in and they're great and they get implemented, but I find that to be interesting that that's happening to me more and more often.
The giveaway, and I mentioned this to Shahrad in an article recently, the most telltale sign to me that when somebody's handing me something in terms of draft form are, and I won't remember the ASCII numbers for them, but the completely vertical quote and apostrophes from the simple ASCII keyboard as opposed to a curved one. Those to me are dead giveaways that someone has pulled it out of an AI editor, because those don't show up in Word and Google Docs in the same way.
Maybe that's part of the prompt now that you have to put in.
Yeah. Use word appropriate quotes, please, to avoid the scrutiny of Miles.
There are a bunch of college students taking notes now.
So, Shahrad, you had an interesting case on AI waiver and search, and you alluded to it. So let's go there now, if you don't mind.
So there was a case in federal court in the Southern District of New York where the gentleman was indicted, and he then decided before going to his lawyers to put a bunch of information in an AI system. I think it was ChatGPT, and the FBI ended up executing a search warrant on his house, and they went in, took his computer and his phone and a bunch of other things that he had in his possession. And lo and behold, when they boot the computer up and start looking through his chat history on the laptop, and I'm presuming he had the native app on his computer or was logged in. So they were able to just basically go in and were able to obtain all this information he had on the case from those chats. And the court basically ruled that it was not protected by attorney-client privilege, and it was not attorney work product because he wasn't consulting an attorney, and he was just basically sending it out to a third party and not really exercising anything that was remotely a safeguard in protecting attorney-client privilege. So it didn't turn out too well for him in that context. So that's a pitfall, especially if you're a criminal defendant, that you have to be careful about.
That's like a huge, going back to sort of discovery and what we do as lawyers. I think if you have an adversary and whatever that, say it's an individual, right? That individual's communications with their lawyer are clearly privileged. You can't touch that. But if that individual takes those communications that it had with its lawyer, puts them into an AI platform to get a second opinion, okay? It has, I believe, waived that privilege as far as those communications go. And I think as lawyers, you can propound discovery in relation to that individual and anything they've done with respect to third-party AI platforms, potentially. Because, if they're going to take things like that, and I think it's a potential waiver problem, because ChatGPT right on the website says anything you put onto here is not confidential, etc. So when I read that article we were talking about, that's the first thing I started thinking about.
I think the way that the evidence code and discovery is written, Marshall, I believe you are correct. My upspeak or thinking process conversation on it is, it seems, I'm trying to parse it a different way. Socratic method, back to law school. If somebody takes something and dumps it into Microsoft Word and re-edits it, that's not discoverable, even if you're using the 365 plan where it's going back and forth with the cloud. I mean, arguably, it shouldn't be discoverable. So at what point does it become, in terms of using a third-party vendor, where's the line? And in certain respects, where do we want the line to be?
Yeah, I understand the distinction between Word and Copilot or whatever else might be somewhat AI based versus ChatGPT, open source platform, which specifically says it's not confidential. And then also, I think it depends on what you're using it for. Right? If you're just using it to edit a document, this goes to where we want the line to be. I can see that falling on the side of that's clearly, not going to be discoverable or whatever the rule it might be. But if you start asking it for legal advice and second opinions and things like that, I think it starts to open things up a lot more.
And now you got me into the world of whether a legal focused update, because I know Anthropic had a legal focused update recently. If you have a legal focused update and a subscription plan, does it reach a point where it's attorney-client communication? And at what point is it not a machine anymore?
Well, I think in order for there to be attorney-client privilege, you got to have individuals. You got to have people, right? Taking it sort of back a couple steps and things that you need to ask for. We're used to asking for all communications between one person and another person, right? Or one person in this particular business. I think now you need to ask for communications between a particular person and a particular AI platform or all of them. Because I think employees, before they submit memos now and things like that, they're asking AI, did I get this right? You know what I mean? Like really probably, I don't want to say dumb, but kind of dumb, potentially liability-based questions that they aren't going to send to that person, their coworker, but now they're sending it to AI to get confirmation that they're right or they're wrong, or is it illegal or is it not illegal? And then they send the email. And so I think, again, going back to this creativity, you should be asking for those types of communications, because I don't see how they can assert the privilege. That wouldn't be there. That's just more, a whole nother avenue of potential treasure trove of documents.
I'm just looking forward to deposing the Tesla robot that's going to be in everyone's homes in a few years. So
they probably have recorded a lot of things that, yeah.
Yeah, but I mean, this is the type of thing where the law, I think, is constantly chasing reality, and there's going to be many more of these types of opinions that we're going to be talking about going forward, because people will be very creative in how they use these systems and how, others go after the information that may be there or in other platforms.
I have to say, after having read a little bit about Bernie Sanders' talk down on the peninsula recently, I'm really not worried. Within 12 to 18 months, all white collar jobs will be gone, and we'll just all be on universal income, and that includes us. So I've actually already been picking out my cabana. I don't know if you two have been doing that.
I haven't gotten that far yet.
We're waiting for your recommendations. If you can put that in the ChatGPT and send us a memo on it, that'd be great.
It will be discoverable. Any other pieces, AI topics, tech, other things that are exciting you or feel we should be paying attention to in this episode?
I think just, we focused a little more on discovery and sort of technical legal aspects. I think, and you mentioned the rules of evidence. I think, watching out for amendments to the California and federal rules of evidence. There's already been proposals on the federal side with respect to how to treat AI-based evidence. Hearsay rules are going to be redefined as AI evidence starts to get used. Authenticity, how you authenticate the various documents or videos or whatever you might be trying to use, is going to become perhaps more difficult with AI, but hearsay is probably going to be easier with AI because there's no declarant. So I think it's just important to think about those issues if you have trials and you're using AI. If accident reconstruction is still a huge thing, right? On your guys' side, and on both sides are reconstructing. They pay a vendor to do that, who can come in and talk about it and authenticate it. Now, arguably, that field could be one who'd be maybe eliminated because you can have that accident reconstructed by artificial intelligence, but then you got to get it into evidence, and who's your witness to authenticate it, so got to be thinking about those things. And there's a lot of articles that are coming out, very well written, on the various topics that are relating to the federal and California rules. So I think it's just important for us as lawyers to think about that as well as we start trying cases that involve AI.
Good point.
I only make good points, so that's...
I don't know. I've read a few AI written emails from your pro per who disagrees with you.
He has a lot of not kind things to say about me. So,
well, anything else, Shahrad, Marshall, you think we should cover in this episode?
Well, just the one issue we talked about earlier, which was this toy that's a stuffed animal called. Yeah. The company is called Bondu, Bondu. Apparently, they exposed 50,000 plus chats to anybody who had an email account, a Gmail account. So as a parent, be careful in terms of what you're handing your kids, especially if they're, toddlers, and what information those kids provide the AI in interacting with it, and how that can result in reliance on this stuffed animal as if it's a human being, which has a lot of layers to it that we would have to unpack as parents buying a kid or grandkid a toy.
Yeah, I try to avoid the stuffed animal, AI-enabled stuffed animals for my kids. I just give them loaded guns instead.
Mine just get Labubu's. I don't know what's worse.
Labubu's, yeah. Yeah, you do direct deposit for that.
Yeah. Don't get me started. Thankfully, they're not connected to the internet, though.
Well, I think with that, we're coming to a close. I really appreciate our conversations. I always feel more educated and definitely entertained after one of our episodes. So thanks, Marshall. Thanks, Shahrad.
Thanks. It's always glad to be back.
And thank you all for listening. If you have any feedback on any topics you'd like us to cover on the AI show, please feel free to reach out at podcast@coopers.law. And to all you do injustice out there, happy hunting.